The case that I will be presenting is the Canadian Broadcasting Corporation v. the Attorney General of Ontario, 2015 ONSC 3131. Here are the facts. The applicant's Canadian Broadcasting Corporation, known as CBC, the Canadian Journalists for Free Expression CJFE, and RTNDA Canada, known as RTNDA, collectively known as the media applicants, allege that the practice without prior judicial authorization of impersonating journalists for purposes of criminal enforcement violated certain sections of the Charter and could not be justified under Section 1 of the Charter, which is the interference of government in the lives of people in a free and democratic society. The media applicants also brought in Sean Brandt for a declaration under a separate factum. Collectively, Sean and the media applicants are known as the applicants. The respondents are the Attorney General of Ontario, Minister of Community Safety and Correctional Services, known as the Minister, and Commissioner of the Ontario Provincial Police, known as the OPP, and I shall refer to all of them collectively as the respondents. The applicants sought to make it clear that they were not seeking a declaration that the conduct of the OPP violated sections 7, 8, and 15 of the Charter, but were limiting the relief sought to the declaration that the impugnant conduct violated Section 2B of the Charter, which is specifically the freedom of expression, including freedom of the press and other media of communication. So essentially, the applicants sought a declaratory relief that the respondents violated only Section 2B of the Charter of Rights and Freedoms. It's important to understand the practices that the applicants were challenging, which are media presence surveillance, independent author operation, and Police Order 2.86. There were 5 issues with this case. 1. What evidence exists on the record of a real practice which can be considered by the court on a constitutional application? The practices that this issue is referring to is what I mentioned before: independent author operation, Police Order 2.86, and media presence surveillance. 2. Do the pleadings limit the scope of the conduct that can be reviewed in the application? Number 3. Does any of the impugnant conduct violate Section 2B of the Charter? 4. If any of the impugnant conduct violates Section 2B, is such conduct a reasonable limit prescribed by law and justified under Section 1 of the Charter? And 5. Is the declaration sought by the applicants appropriate declaratory relief? The decision was that the application put forward by the applicants was dismissed. Here's the rationale. The idea of a real practice was one of debate in this case because there were 3 practices: independent author operation, Police Order 2.86, and media presence surveillance, but only media presence surveillance was considered the real practice. However, there was also no evidence that the practice outlined in the job description of this operation, media presence surveillance, which included to responding to any identity questions by posing as a journalist, and therefore the whole thing doesn't actually constitute impersonating a journalist at all. And in addition, there's also no evidence of any practice of impersonating journalists arising out of the independent author operation or from Police Order 2.86. So really, all that the applicants can actually challenge is the real practice of media presence surveillance, which actually did not practice the impersonation of journalists, which is what the applicants are challenging. And in addition, the idea of what a real practice is a practice is something we do over and over again. And as the respondents submitted that independent author operation and Police Order 2.86 could not actually be considered real practices as they were only one-time instances. And in addition, the respondents also submitted that whether or not media presence surveillance constitutes as impersonating a journalist, the applicants could still, however, challenge the practice under Section 2B of the Charter. But the evidence brought forward of any impersonation, if there was, did not satisfy the judge that there was a chilling effect on the freedom of expression. The applicants claimed that with government interference in day-to-day affairs concerning journalism, that therefore restricted the flow of information and also posed a risk to other real practicing journalists. However, this was too casual a link, and there were many disputes about the definition of what impersonation means and what the phrase impersonating a journalist means. As there was too casual a link and not enough evidence, this application was therefore dismissed, and as there was no real practice at all, there also wasn't anything to actually challenge in the first place. So here's a revisitation of the issues, and this is what the rationale all addresses. What evidence exists on the record of a real practice? Well, we have established that only media presence surveillance is the only real practice in this case. And there is a limit of the scope, because now we are not considering Police Order 2.86, nor are we considering independent author operation. And does any of the impugnant conduct violate? As there was no actual conduct, so to say, done by the media presence surveillance that so-called impersonated a journalist, there's in fact no violation of any Section 2B of the Charter. And as a result, as there's no conduct that actually violated anything, all the other issues show that there's nothing that the applicants can actually challenge, and therefore there's no such relief that the applicants can actually want or declare. And the analysis here is that I personally thought a lot of this case had to deal with what a practice was, what does journalist mean, what does impersonation mean. And in my opinion, I do agree that the application should have been dismissed, because as a primary issue was what was considered to be a practice. The original application filed by the applicants only challenged the media presence surveillance, and not the independent author operation or the Police Order 2.86. This created a huge prejudice when the applicants tried to state that the latter two also violated their charter rights. Therefore, the only real practice was media presence surveillance, but the role of the officer involved was only to blend in and hide in plain sight, and therefore cannot be classified as a practice of undercover operations that puts other real journalists at risk. In actual fact, the officers involved weren't undercover operatives tasked with interacting with any suspects for the collection of confidential information, never interacted with any members of the media at all. So in a whole, media presence surveillance, independent author operation, and Police Order 2.86 don't constitute any action of practicing the impersonation of journalists. If there's no actual practice of impersonation of journalists, the respondents are in fact not violating any charter rights of the applicants. Therefore, I do overall agree that the application should be dismissed. Here's my survey question. As I mentioned before, there are a lot of issues of defining what this phrase meant, or what that expression meant, or what that word meant, or what a real practice even is. So my question is, do you think that the fickleness of definitions of words and phrases in this case contributed to the application of the applicants being denied? The end. Thank you.